There is a lot of hue and cry after the BNS Bharatiya Nyaya Sanhita 2023 came into force on 1st of July in the medical professionals. Medical professionals are having a feeling that the new act has stringent provision and it is directly making an attack on the medical professionals, and it is very difficult for the medical professionals to come out of the rigors of criminal law. Let us examine whether there is some reality into this fact or not, whether the law is so stringent and there is a complete change in the law, or the law is same and it is only an apprehension. Now, so to understand all this, first we have to see what is the provision under the old law, that is Indian Penal Code. It was section 304A of the Indian Penal Code, which prescribes causing death by negligence. There is no reference about the doctors or the medical professionals. But under the definition of causing death by negligence, the medical professionals were implicated under the Indian Penal Code. Now I'll read this provision for your benefit. Section 304A, causing death by negligence. Whoever causes the death of any person by doing any such rash or negligent act not amounting to culpable homicide shall be punished with imprisonment of either description for a term which may extend to 2 years, or with fine, or with both. So meaning thereby, if due to the rash and negligent act of a person, a death has been caused which is not amounting to culpable homicide. It is another area of discussion. We will discuss in another video what is culpable homicide. Then the punishment prescribed is imprisonment of either description for a term which may extend to 2 years, or fine, or with both. Meaning thereby, the court may award the imprisonment maybe for 1 day, maybe 3 days, maybe 6 months, maybe maximum of the period of 2 years, or may impose only fine, because the word is 2 years or fine. So the court has the discretion to award the imprisonment in the shape of fine only, maybe for 1 rupee, 100 rupees. Or with both, the court may impose the imprisonment in the shape of 1 year, 2 year, 1 month, 2 months, along with the fine also. So this was the provision under the old law, that is Indian Penal Code. Now under the new law, that is BNS Bharatiya Nyaya Sanhita 2023, the corresponding provision is 106. It says causing death by negligence. The title is same, but here there is some difference, not in the ingredients of the offence, but a reference has been made in regard to the medical professionals. But the basic ingredients of the offence are same. For your benefit, I am again reading this provision under section 106 of the BNS Act. It says, whoever causes death of any person by doing any rash or negligent act not amounting to culpable homicide, so up to the requirement of ingredients of the offence, it is same, verbatim same, no further extended requirement or a lesser requirement. The previous provision under the IPC and the new provision under the BNS Act, the requirement of the offence, the ingredients of the offence are same. Now regarding the punishment, it says shall be punished with imprisonment of either description for a term which may extend to 5 years. Now that period of 2 years have been extended to 5 years. Then it says, and shall also be liable to fine. There it was in the old provision, or imprisonment or fine, or both. Here it says imprisonment and fine. So imprisonment can be imposed, fine also be imposed, and then and it if such. Now this is another part. So meaning thereby up to this extent the definition is same, but however in regard to the sentence part it has been enhanced to from 2 years to 5 years. Earlier it was or fine, now it is and fine. So both have to be imposed as a part of the sentence. Now the subsequent part of the subsection 1 of section 106 of the BNS Act pertains to medical professional. It says, and if such act is done by a registered medical practitioner while performing medical procedure. So meaning thereby, if this rash or negligent act has been committed by a registered medical professional, then he shall be, while performing the medical procedure, we'll discuss what is the scope of medical procedure, he shall be punished with imprisonment of either description for a term which may extend to 2 years and shall also be liable to fine. Now, if we understand 304A and 106 in the context of medical professionals, yes, a specific terminology and liability has been created for medical professionals under section 106. But under 304A also they are liable. The ingredient of the offence is same. But here medical professionals have been defined. And then if they have done this act in the performance of medical procedure. What is medical procedure? It may be diagnosis. It may be a procedure of surgery. It may be giving the prescription of medicine. Whatever it may be. It includes everything. But the punishment is 2 years and fine. This is the only difference. So in nutshell, if we understand, then there is no difference at all of the previous provision and the liability of the doctors, medical professionals, and under the new law. There is no difference, except we can say a specified terminology has been used for the medical professionals, one. Second, the punishment is 2 years and fine, whereas in the previous provision under the old law, it is 2 years or fine. Here it is 2 years. It is 2 years is the maximum. The court may award the punishment of rising till the court may award 1 day, court may award 6 days, court may award 6 months, court may award to the maximum of 2 years and the fine. So if we understand in the legal parlance, there is not much difference where the medical professional has to worry about it. Now medical professionals, registered medical practitioners, the word used has also been clarified. Who are the registered medical professionals? Registered medical practitioners. Explanation says, for the purposes of this subsection, registered medical practitioners means a medical practitioner who possesses any medical qualification recognized under the National Medical Commission Act 2019 and whose name has been entered in the National Medical Register or a state medical register under that act. So they are the medical practitioners covered under section 106 of the new act. Now what is the nature of this offence? Under the law, this offence is cognizable and bailable. Cognizable is considered to be a little bit serious offence, and under the provisions of the new law also, an FIR can be registered where the offence is cognizable, but it is bailable. Bailable means where a person, if involved, implicated in a criminal case of a cognizable nature under section 106, he will be granted the bail either by the magistrate before whom they will be produced as a matter of right, or before the police also. Now the question arises, the doctor the medical practitioner, registered medical practitioner, has done his duties with due diligence, with due prudence, and as per the procedure prescribed under the medical studies. What is the defense available to him? One is he should face the trial and get his acquittal in case he proves his prudence while discharging the duties. Other protection is the earlier laws interpreted by the Honorable Supreme Court, be it Jacob's case or be it Lalita Kumari's case. Those directions still holds good because the parameteria provision under the new act is same. So those laws have the validity, and those laws declared by the Honorable Supreme Court has the same status being the law of the land. What is there? In case a complaint is filed against the medical practitioner, then it is not that the police shall register the FIR immediately. They have to hold the inquiry, find out the real reasons, get the medical expert opinion, and if it amounts to prima facie the medical negligence as covered under section 106, only then an FIR should be registered. So I think, as per my understanding, there is not much difference in the previous and the old in the previous old law and the new law, except a specific reference to the medical practitioners. I hope you understand this, and all the fears should be evaporated in view of the explanation submitted by me. And in case of any query, you are always welcome to give your comments, and I'll explain further if something is required in this regard by the medical practitioners. Thank you very much. God bless you.